Good afternoon. We want to welcome everybody to the Tennessee Court of Appeals. Your panel today consists of myself, Judge McClarty, Judge Friesen, and Judge Davis. Madam Clerk, are there any preliminary matters?
No, Your Honors.
Will you please call the first case?
Jennifer Gaby versus Tony Gaby.
I assume that the rebuttal time has already been reserved.
I would like to reserve 5 minutes.
5 minutes. You may proceed for the appellant.
Thank you. My name is Crystal Jesse. May it please the court, I am from the Greene County Bar, and I'm here representing Mr. Tony Gaby, the appellant in this matter. For the argument purposes, I will also refer to him as the father in this case. I will bring attention to the history of the case. The parties were divorced in August of 2017. During the course of the divorce litigation, my client, the father, had 6 out of 14 days with the children, almost equal time. After the trial, the Judge Wright, put down a parenting plan giving the father only 52 days with the children, essentially every other weekend. Judge Wright stated on the record, as you can see, that it mostly had to do with him being a truck driver and his schedule. Also some other issues in regard to the children not transitioning as well, and suggested they go to therapy. A year went by. In August of 2018, we filed a petition to modify. The father had gotten new hours where he was working 1 a.m. to 1 p.m. so he could facilitate anything the children did after school. Additionally, he had a girlfriend that was getting along very well with the children and moved in. He went to therapy with the children. As you can see in the record, Miss Carrie Eastep was the therapist that did the therapy. He reached out to the mother and asked the mother to go to therapy, and the mother told the therapist and the father, I'm not the one that needs therapy. I'm not the one that has the issues. He asked the therapist how to introduce the children to his new girlfriend. The therapist walked him through it. Everything seemed to be going well. Alyssa especially had developed a bond with the new girlfriend and is really thriving. Both of them were doing well in school. So we filed a petition to modify, and during the course of litigation, I take the deposition of the children. Alyssa stated in her deposition she wanted more time with her father. Piper was more ambivalent and wanted things to stay the same. Notably, we finally get to trial in December of 2019, and an order doesn't go down until April 2020. This is the second time we've been to the Court of Appeals. The first order went down with no specific findings and only gave the father 90 days with the children. I filed a motion to alter and amend asking for the factors of 36-6-106. The court summarily denied it without a hearing. I appealed. You all remanded and asked the court to make specific findings, which the court did. Interestingly enough, the court did not give any more time, and the factors seem almost disputed. I specifically pointed them out in the brief, and I won't take time to go through them step by step today. But what seems to be the motivating factor for the trial judge was the decision of Piper. Now, the factor is very specific. When you look at factor 13, it's supposed to be the reasonable preference of a child. What it appears to be is that the court erred in not maximizing the father's time, seemingly only to consider Piper's desire, and failed to weigh all the factors. Additionally, it's notable to mention the children testified different when we got to trial. Piper said she wanted no time with her father, and Alyssa said, well, I really don't want more time, and I kind of want to stay with my sister. It was concerning at best, especially when the court specifically found that the mother did nothing to help foster the father's relationship.
Is the older one about to age out? Is she will, so we'll really just be dealing with Alyssa?
Yes.
Okay.
Yes, and depending on what happens, we're in a position where we may file to come back again. But mainly, the court didn't really take issue with what the mother did to not just omit and not help the father, but to thwart the father's relationship with the children. The mother isolated Alyssa. Alyssa had a good relationship with Michelle, the girlfriend. Alyssa was her Snapchat friend. As Alyssa testified, her mother made her delete her from Snapchat to the point that Alyssa deleted the whole app. Alyssa had the girlfriend's number in her phone. The mother made her remove it. So there was little things that the court didn't take into consideration. Despite the overwhelming evidence, it seems truly that the trial judge gave the most discretion to Piper's wants and desires, reasonable or not. What is even more interesting is that I cited to two cases that I believe are exactly on point. One is the In re Lennon R, and one is the Nevaeh versus Nevaeh. Specifically in In re Lennon R, in that case, the mother and father had a temporary plan, as you saw in this case, in which the mother had a little bit more time, not exactly equal, and the father was not the primary residential parent. Then when they went to trial, the trial court gave the father the primary residential parent and limited the mother to 100 days. The trial court said no, that the sole factor that the parties live in different counties is not a sufficient enough reason to limit a parent to just 100 days. It's an illogical conclusion. I believe the case on point, the trial judge said in the original trial, if you get a new work schedule, we'll maximize your time. You'll have more time with your children, actually, because Armbruster wasn't down then, but you'll have more time with your children. Armbruster comes down, he's doing better, he gets a new job, yet he's limited to 90 days. And there's no reason why we didn't maximize the time. Then we point to Nevaeh.
Wasn't there a problem with the work schedule as to the time he was actually at work and the time he had that he would have spending with the children?
No, if you look at the parenting plan, what he did during the school year, the children primarily reside with the mother, in that she has them. My client only has every other weekend. In the summer, we do a week on, week off. Now remember, my client lives in the same home he's always lived in since the children came home from the hospital. He helped raise them in this home. Even when they were split up, he was taking them to the same school. So the fact is, he would leave that morning. His girlfriend or his parents, who had helped facilitate transition before to and from school, live across the street, would have to take them to school. But he gets off at 1 p.m. We could have these children every day after school. I actually asked the court about that. In the last pages of the transcript, you will find, I said, Your Honor, what about after school? Let the father pick the children up. And the court's response was, well, the children have something to do every day. Yes, the children have something to do every day, but you have a mother that works until 5 p.m. Why can't we be the ones to transport them to and from school and their activities? And the trial judge said, well, make sure the mother just gives you the schedule so you can show up and be there. Being there and being able to transport them, being able to pick them up, being able to have some input in that is a big difference. Additionally, you're looking at the children sleeping. The father would have a good 10 hours from 1 p.m. to 10 p.m. every day after school. They would go to bed, so his hours away from the children working would be sleeping hours. So it really didn't make sense when we asked for more time during the school year when you have two children that are older in age and capable of getting themselves up. Why, if it was a 2- and 3-year-old that would have to have hands-on care, it'd be a little bit different. But why children at middle school and high school and high school and high school now, why would we put so much emphasis on a parent not being there? A perfect example is the mother went on vacation for an extended period of time, and the father asked, while you're on vacation, can I not keep the children? She said no. If we're maximizing the time with the parents, wouldn't we foster that relationship rather than leave the children with a third party? The only reason we have is because of Piper's testimony that had changed. And the logical conclusion is, as the court said in the Nevaeh versus Nevaeh, the relationship between the child and each parent should be fostered because of the fundamental importance of the parent-child relationship to the welfare of the child. The only way we can foster that relationship is to have more time with the children. Additionally, this court noted that the prior period of equal parenting time in that case allowed the children to develop a closer relationship. And that's the same in this case. If we don't have more time, we don't have the ability to foster that relationship and to gain a closer relationship with the children.
The trial judge seemed to be of the opinion that there was a serious block between the oldest child and the father and the new living girlfriend because of her finding out that this relationship occurred prior to the divorce. What can be done about that, if anything?
Actually, thank you for bringing that up. That revelation came about at the last trial. So you think about this, during the first trial that wasn't mentioned, during therapy that wasn't mentioned, lo and behold, when everything's going good, and as Ms. Estep stated, the therapist, she saw no issue with the children. And yet when we get to trial, Piper says, I have an issue with her because of the alleged affair. I think if we order the mother to go to family therapy, as she should have voluntarily went, if we ordered the mother to make her child go to visitation, and if we make everyone sit in a room and try to do what's right, then we can rebuild this relationship. But it is interesting that that reason came up in trial after we had taken depositions and had a prior trial and testimony.
You have time for your rebuttal. Thank you very
Thank
much.
you.
Good afternoon. May it please the court?
Yes.
I'm Joseph McAfee from Greene County, and I represent the appellee, Jennifer Gaby. In formulating what may amount to what I'm trying to frame as a theme of my argument is, it's well established. The interests of the parents in these custody and parenting plan cases are secondary, and the primary focus and what is paramount are the interests of the children. Now, I don't necessarily want to be perhaps overly aggressive, but if we look at the record in the case, the testimony from the trial, and even the arguments of the appellee, Mr. Gaby, or the appellee's arguments are focused on him, what he's got. If you look at the last page of the brief, and the argument and the issue, which is, did the court err to maximize the appellee's time with the children? Well, all due respect, putting myself out on a limb here, but that's not the standard. To maximize the participation of the parents in the lives of the children consistent with the best interest factors. And so whenever we go back and we look at what the trial judge did after the divorce trial, you need an anger management class, Dad. He checks that box. Some family counseling and therapy. He checks that box. But if you look closely, and I was the trial counsel of record here, I disagree, and I'm going to summarize that before I finish. I disagree with some of the factual assertions either in the brief or maybe the appellee here this afternoon. The therapy sessions with Ms. Estep, I respectfully disagree. I think those were separate. Ms. Estep would meet with the children, and she would meet with the dad. I'm not aware of there being in the record any sessions where they're together trying to work things out. It seems as if Ms. Estep was serving as sort of a mediator with the family and other parties in like a mediation in separate rooms. So we look down all the way through the facts that both parties have asserted here. We have, there's an attempt to paint the appellee as someone who is attempting to alienate the children from the appellee. Well, with all due respect, we submit the appellee's done that himself. There's not any testimony.
You keep saying the appellee.
The appellant.
Yeah, the dad,
Look at that
the
sign,
appellant.
yes,
Okay, just making sure we're on the same
Yes,
page.
the appellant. I should have just started saying Mr. Gaby and Miss Gaby, but Yes, ma'am, but the fault, with all due respect, lies with the appellant.
Well, the trial judge did recognize that he did make some improvements, and he did do some of the things that were required of him to develop a better relationship. And he did increase the time initially, didn't he?
That is absolutely right, Your Honor. The trial court ordered, hey, do these things and come back. He fell short of saying, hey, I'm going to modify the parenting plan, wisely so. I think that was probably a good choice on the court's part, but Mr. Gaby did take into account what the court directed him to do. But with all due respect, it seems as if the appellant is checking boxes. I mean, he took the anger management class. There's still testimony at the trial after he took that class of him and his living girlfriend getting into a shouting match as testified by Alyssa. And the court, in fact, did increase his time from the 52 days to the 90 days. And it appears to me as if the court was very careful to tailor a parenting plan, which I'm sure we said that in the brief. We respectfully disagree with the court's decision to find a material change in circumstances, though we didn't raise that as an issue, and to increase the father's parenting time, because I can see how a objective trier of fact or Your Honors may see this record and say, okay, well, let's increase the time. But the court was very careful to tailor a parenting plan and a residential schedule in the way that he did, which increased the father's time with the children during the holiday time and during the summer. And it's easy to draw from that the court was very concerned about making sure that the children and their educational needs were met. Miss Gaby is an employee of the Tennessee Education Association. She has worked very well with the children, and the record supports both of these children are doing outstanding, both socially and academically, as well as in terms of athletics as well. These are children that from the time of the divorce to the time of the trial, whenever we have the facts as testified to, they're doing outstanding. So there's something that's being done right here, and it's the appellee's efforts in trying to raise good citizens that are preparing themselves for a lifetime of service to others. So,
one question. Now, the oldest child is going to max out, okay? I think in November, something like that.
yes, sir.
Now, the youngest child, she did not have the major problem with the father and the new girlfriend. She was basing her feelings, from my understanding, based upon those of her sister. Why should not the father have more time with her?
It's an excellent question, Your Honor. Well, based on, I want to play fair. I want to talk about what's in the record. The interactions with the father, as set forth in the appellant's brief, are we go grocery shopping. Well, with all due respect to that as well, that's fine. Everybody takes their kids grocery shopping, but if you have limited time with your children, you need to be spending time with your kids doing things other than things you could do in the 12 days in between your visits. And then as far as the time that's spent at the father's house on the weekends, there's talk about what the younger child wants to do and likes to do, like fishing and four-wheeling and that sort of thing, which is all good. But there's also testimony about, witnessing the arguing and fighting and spending time on social media with the father's or the appellant's living girlfriend. Well, the interaction about the Snapchat and the appellee's wish to restrict access to Snapchat, or specifically the girlfriend, I don't want to overstep here, but I think it's inappropriate to take up for a child having unrestricted access to social media. It causes tons of problems. So,
But the issue, as I recall, wasn't necessarily her access to social media, it was specifically her communication with the girlfriend that the mom objected to, and then the daughter, and then the child said, well, fine, I'm just going to delete the whole app.
that's correct, yes, ma'am.
Okay, why would
Well, I'm sure that in looking back, trying to stay within the record and play fair, in looking back, I'm sure it's perfectly natural to have some concern about someone else coming into the lives of the children that you don't have a whole lot of knowledge of, and you don't have any influence over what this person may be doing to influence your child. It's not something I've had to deal with personally, but professionally, it appears that may be a concern that, legitimate or not, is a very natural parental tendency to want to not limit, but certainly have some influence over who your children are around. Whenever we have a divided parenting plan, that's something that we just have to live with. So, and getting back to what some of the testimony was at the original trial, all due respect, we disagree that the appellee, Miss Gaby, was thwarting the relationship. There was some discussion by the trial court, of course, about at the divorce trial, the ruling in the transcript is there. The appellee, Miss Gaby, was applauded by the court in terms of not disclosing things that could have easily been disclosed. And then we get to this trial, there may have been, from what the trial judge observed, perhaps a difference in approach or difference in attitude from Miss Gaby, because perhaps she's just getting tired of it. You know, she has supported, or she previously supported the children and facilitated and encouraged the children. There's no testimony that she discouraged. All right, she's already ordered to send Piper to the father's house, the appellant's house. There's no motion for contempt that's in the record here. She has already previously ordered to make the children follow the parenting plan because it's a court order. So, is she taking it upon herself to improve the relationship of the appellant and the children? I can't see that that's in the record of what's before the court previously, before the divorce. Of course, that seems to be what was going on. But there's certainly no indication from the record that would support that she's thwarting this relationship. In fact, there's testimony from the Miss Gaby, couldn't tell you exactly which page, but during her testimony of the trial, she stated, I'm not going to let my children be rude, and I'm not going to let those children disrespect their father. That's their father. Well, that's pretty strong evidence that she's not there to try and destroy that relationship. I'm sure she would rather that relationship be stronger, but with all due respect, it seems as if she is perhaps a little frustrated with the way things have worked in terms of the work she's done with the children, and that the appellant wants to be rewarded for checking boxes. And as we know, that's not something that our laws want to promote in terms of parenting plans are not there to be a reward or a punishment for any particular parent. The focus needs to be the best interest of the children. Now, with regard to the work schedule, originally it was going to be awful difficult for the appellant to have as much participation in the lives of the children. At this point, if he is getting off work at 1 o'clock, assuming he's still on that schedule, he can come to any after-school activities there are. There's no restriction on that. It's not like he has to stay away from the appellee. He can participate fully. And with regard to his work schedule, he goes to work at 1 o'clock. His children are at home, could possibly be alone. His living girlfriend is there. We don't have any sort of criminal concerns or anything of that nature, but that's not necessarily a permanent looking relationship. It's a girlfriend. This is not a stepmom. I'm sure the stepmoms and stepdads watch after children of the other parent whenever they're at work a lot of times, but what we want is stability in these children's lives, and they've been getting it. They've had it from the time of the divorce until now, and they are absolutely flourishing. So the court goes through all the best interest factors, and he makes a lot of findings that some of the factors go in favor of the appellee. We certainly agree with that, as set within our brief. We tried to be fair in our assessment of the case, and the court did not abuse its discretion. So even though we respectfully disagree with how the court ruled in increasing the parenting time of the appellant, we're going to have to say that the court was within its discretion in fashioning a parenting plan that very clearly is supported by the record and fashioned to serve the best interests of the children, which is the paramount concern here. Unless your honors have any further questions, I believe that wraps up mine.
I hear none. Thank you very much, sir. Yes, ma'am, your rebuttal.
Thank you. I want to clarify some things. On page 14 of the record specifically, Ms. Estep testified that she did therapy. She did therapy between the father and the children. Additionally, when she heard allegations She asked the children, specifically Piper, who she heard about the extramarital affair from, and on page 16, Piper says, friends, oh, and my mother. The therapist on page 17 also assesses that Alyssa has a stronger relationship than Piper. And then you go on page 19 and 20 to talk about how the mother has kind of thwarted the relationship between Alyssa and the girlfriend, going on into the Snapchat situation. So it's absolutely evident that the therapist did family therapy. She talked to the children separately. She spoke with my client separately. However, she also did family therapy between them. We're asking your honors to remand this matter with instructions to maximize the time, just as you did in Nevaeh versus Nevaeh and in Ray Lennon. As I mentioned earlier, specifically, if you looked on page 266 to 267, I asked the court, give us time. Give us time. If you're not going to maximize the time during the school year, why do we not have the majority of the summer? We know Alyssa enjoys doing the outdoor things with the father. If it's the school year you're worried about, give us time during the breaks. But there's no testimony that it was the school year. So why can we not even do, as I said, Friday to Monday morning, afternoons? It makes no sense that you have a gentleman that was working a worse schedule during the divorce and had 6 out of 8 days and has been digging himself out of this hole ever since. The Armbruster standard, I know because I wrote the brief, Tom argued it and tried it in front of Judge Frierson, is to maximize the time with the parents. Yes, he can participate, as counsel said, after school. However, participating and being the parent that picks the child up from school and takes them to their extracurricular is a big step, and is something that Armbruster states we maximize the time with the parents. The mother's working during this time. Why wouldn't the father be a logical person to do that? And why wouldn't we give him the days and the time to do that? I understand counsel's opinion that the mother may have had a different attitude during the second trial. There isn't a may in this. The judge specifically found that the mother had not fostered the relationship between the children and the father. Something as simple when she could have showed up for therapy, and because of that, the relationship suffered. As in Ray Nevaeh, we can only build back the relationship if we have the time to do that. There is no reason stated in the record why we should not have more time and maximize the time with the children. Do you all have any other questions?
I hear none. Thank you very much.
Thank you.
I want to thank both of the parties for your presentation before this court. Your case has now been submitted to the Court of Appeals. You should receive our opinion within a reasonable period of time. Thank you both. You may be excused.